The matter before the court, reverse Batson, however you want to describe it. The court, when this type of motion is brought before it, is asked to do really two things, make two primary findings. The first of which, this court has found that there appears to be intentional discrimination in the panel. That's that prima facie case. And I guess before I get into this, one of the challenges that I think counsel recognized in this case is the racial overtones in the case. And those can't, at least here, without the jury present, based on the questioning, we have not been able to escape those discussions with the panel, and they've just come up in a lot of different contexts. So, you know, this is sort of a continuation of a conversation that I think will continue for a long time with respect to this case and maybe many others. And so we start getting into this question about race. And again, quite a few African-American jurors were excused through peremptory strikes exercised by the defense. But that doesn't mean that the court has the authority to reseat simply, again, because there's this prima facie case, because we see it. It's sort of one of those, it's not one of those we see it, therefore it is. There's now additional steps the court needs to engage in. One of those steps is the exercise we just went through, which is going through those particular strikes and hearing from the defendants in this particular case on a reverse Batson on why those strikes were exercised. And then based on all of that, the court is in a position where it's got to make another finding, which is that the defendants are not genuine when they gave a reason, and that the reason they were claiming is not the real reason those particular jurors were struck. Batson is very limited in what it actually provides the court with as far as an instrument, because, at least in the state of Georgia, the court, if it hears a legitimate, non-discriminatory, clear, reasonably specific, and related reason, and reason related to the case, that is usually enough to get the court to a finding in this third phase where the panelist doesn't need to be reseated. There are other states that have a different approach, actually get much more specific. I'll point to Washington as one of those states that's looked at Batson and recognized the limitations it places on the court. But effectively what the court's being asked to do here is determine whether or not the defense is not being genuine with respect to these strikes. And there's all sorts of case law out there, including case law about whether or not you're treating, in this case it would be African-American potential panelists versus Caucasian, how specific the questions have to be and how closely related they are. And I'll tell you, in this particular case, Batson's limitations, I think, are clearly out there. In this particular case, there are these significant overtones of race to begin with. And then we have numerous additional peremptory strikes. We're not just limited to the ones that statutorily sit out there. And then we have extensive questioning of each of the panelists, which start differentiating everybody for different reasons based on answers that are given. Because of that, it becomes very difficult for the court to start working through this problem of, are these really genuine reasons that are out there? And it gets to the point that I think was raised actually in the Batson decision. I wrote it down. It's Justice Marshall in his concurrence was talking about Batson. And he said specifically, the decision today will not end the racial discrimination that peremptories inject into the jury selection process. And the reason he said that was because his view of it was that peremptories just give the parties the opportunity to place the court and the system into this this balancing of race versus legitimate purpose. And again, this case makes it difficult because race has been injected into this process and we have a significant number of peremptories. All that's to say, I've worked through each one of these. I've listened to the defense. Again, in the state of Georgia, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason. I have very adept counsel here, and they've been able to explain to the court why, separate from race, those individuals were in fact struck from the panel. It does not change the fact that that initial finding was out there. It doesn't feel like that is how it worked, but it's been explained to the court under the terms of Batson why those particular strikes were made. And the court is not going to place upon the defendants a finding that they are being disingenuous to the court or otherwise are not being truthful with the court when it comes to their reasons for striking these jurors. So because of that and because of, again, the limitations I think Batson places upon this court's analysis, I'm denying the motion. Anything from the state?
Nothing other than scheduling and the future. Other than that, nothing.
From Travis McMichael.
Thank you. Your Honor, I just want to place something on the record with respect to the court's comment of Justice Marshall's opinion that Batson won't end racial discrimination in jury selection. And I say this on behalf of a team of lawyers who have been very careful about all this and have had to juggle and weigh all of these interests, that what the court found is what you would have found is no discriminatory intent in exercising the peremptory strike, that you found that they were genuine and race neutral. So I point out that in a normal case, anything outside of what we're doing here today, the three statutory questions the court would have asked: have a juror formed and expressed an opinion? Is your mind perfectly impartial between the state and the defense? Is there any bias resting on your mind, either for or against the accused? In most cases, when those jurors raise their hand, that's the end of the inquiry. In some cases, they're called in to discuss that, and if they still hang on to those opinions, they're off the jury. So what I wanted to make clear to the court, to the gallery, is that what we have to do in a case like this is to scrutinize the ability of those jurors who said, I have an opinion and I feel this way about the case, but I understand the law and I aspire to put my opinions, knowledge, and relationships aside. And in scrutinizing those jurors' ability to do that, what becomes clear is the court's opinion in Georgia versus Collum, the case we're here on today, in that Justice Blackmun says very clearly that there's a distinction between exercising a peremptory challenge to discriminate invidiously against jurors on account of race and exercising a peremptory challenge to remove an individual juror who harbors some bias or prejudice. Batson was meant to address stereotyping, drawing inferences about a juror's ability to serve based solely on his or her race, and we stand as a team to make it clear to the court, and I appreciate the court's understanding that that is not what we did, and that we had to accept the realities of the limitations of what kind of jury panel we were left with, given the notorious nature of this case and the overwhelming publicity.
Well, the court's already indicated where I sit on it. That is with the defense's position, and again, I've explained what I believe are the limitations with regard to Batson and this court's analysis. Under the circumstances of this case, I explained my ruling, and that's where we are.